adjourns NNAMDI KANU'S ₦1 billion lawsuit against federal government for adoption of procedures. A federal high court, Abuja, has adjourned a ₦1 billion suit filed by NNAMDI KANU, leader of the proscribed indigenous people of Biafra, against the federal government and Department of State Services until April 23rd for adoption of processes. Justice James Omotosho adjourned the matter after lawyer to the Attorney General of the Federation, Benga Oladimeji, filed a process shortly before the hearing commenced. Justice Omotosho, who was unhappy over Oladimeji's delay in filing the motion, subsequently adjourned the matter for adoption of processes. The News Agency of Nigeria, NAN, reports that on April 18, Oladimeji had informed the court that they were yet to file their response on behalf of first and second defendants because he was only being notified about the process, though they had been served since March 6. But the DSS lawyer, Abdulsalami, said they had filed their counter affidavit in opposition to KANU'S application filed by his counsel, Aloy Ejimako. Ejimako then sought an adjournment to enable him file a further affidavit in response to fresh issues raised by the DSS in their counter affidavit, and the judge adjourned the matter until today for adoption of process. NAN reports that KANU, through his lawyer Ejimako, had filed the instant suit marked for the enforcement of his fundamental rights while in detention. The suit was filed pursuant to Order 2, Rules 1 and 2 of the Fundamental Rights Enforcement Procedure Rules 2009, among others. In the motion, the detained IPOB leader prayed for 8 reliefs. He sought a declaration that the respondent act of forcible seizure and photocopying of confidential legal documents pertaining to facilitating the preparation of his defense, which were brought to him at the respondent's detention facility by his lawyers, amounted to denial of his right to be defended by legal practitioners of his own choice. KANU therefore sought an order of injunction restraining and prohibiting the respondent from the act of forcible seizure and photocopying of confidential legal documents brought to him at the detention facility by his lawyers. He is also seeking an order mandating the respondents to jointly and severally pay the sum of ₦1 billion as damages for the mental, emotional, psychological, and other damages he suffered as a result of his rights breach. He argued that, according to Benye, the applicant, KANU, is allowed access to his family members and team of lawyers on his visiting days without any hindrance whatsoever. He argued that the IPOB leader was permitted to interact and consult with his lawyers on his visiting days without any interference. He said at no material time did any DSS personnel seize or confiscate documents brought to KANU by his lawyers or any other person. The official who denied allegations that the personnel usually record their interaction during visits said there is no basis for eavesdropping and recording of their conversation. He said, in line with the Service Standard Operation Procedure SOP of the State Security Service, all visitors to our facility are subjected to normal routine security checks and items in their possession scanned. According to him, this is to avoid unauthorized materials making their way into the facility. Benye said the instant suit was an abuse of the court process, KANU having argued the same issues before Justice Nyako and the matter reserved for judgment. This is the news for today. Don't forget to like this video, comment under this video, and subscribe to this channel for more news.